$10,000 in cash bail in certain conditions. The first one being that.
Mr. Keeney, how do you wish to plead, guilty or not guilty?
Not guilty.
Thank you. You can have a seat. Question of bail, both cases.
Yes, Your Honor. The Commonwealth would be requesting $10,000 in cash bail in certain conditions. The first one being that the defendant stay away from the alleged victim in the case. Secondly, that he obey all outstanding restraining orders regarding the victim. And thirdly, requesting that there be a GPS monitoring with just an exclusion zone as to the victim's home, place of work, or schools that her children may attend.
All right. There are a number of different victims in connection with both matters, correct?
Yes.
So you're asking for a stay away, no contact with all named victims?
Yes.
Okay.
Yes.
And the GPS exclusion zone would relate to all as well?
Yes. It's not required, obviously, to keep the defendant in home or just away from the particular victims in the many cases.
How many separate victims do we have? I haven't gone through and identified them.
There were like 8.
Okay.
Correct.
All right. Okay. And why is the Commonwealth requesting cash bail as well?
The reason that we're asking for cash bail, Your Honor, is because the new charges are exceedingly troublesome. The defendant has already been charged with the multiple counts of intimidating a witness, and there is considerable. It's obviously that he has continuing in this conduct. If I could go over a little bit of the background of the intimidation, the new intimidation of a witness case, Your Honor. This occurred on December 23rd of 2023 at the apartment of the alleged victim, who is Lindsay Gattani, when the defendant came over knowing and for the purpose because she had received a summons to appear before the grand jury. When he appeared at her apartment, he told her in no uncertain terms that when she went to the grand jury, she was going to tell them that she knew nothing about the case. He further told her that he wanted to take her phone and go through it to look for and to erase any particular contacts and data that she might have regarding the matter.
Okay.
He threatened her in saying that if she didn't cooperate, he would destroy her in front of her kids by publishing old probate court records that he had acquired. The second charge under what we call the wiretap statute is that at that same time he recorded their conversation unknown to her and without her permission. The first time she found out about that she was being recorded is when it was published on his website, and then found out that the conversation that was published on the website was not the conversation that she had with him, that it had been altered. Since that time, the police have received a copy of a recording that does reflect what was said, which indicates that she did not consent to the recording. So, Your Honor, the reason that we're looking for bail is obviously the charges are serious. The intimidation charge is a felony. It carries up to 10 years imprisonment. The wiretap up to 5 years imprisonment. It's clear that the defendant has the proclivity for continuing with intimidation even after being charged and being on personal recognizance for this, and we think the bail and the stay away and the monitoring is necessary just to ensure the safety and protection of the witnesses, at least until the trial of Karen Reed can take place, and that to preserve justice and prevent it from being obstructed. So those are our reasons, Your Honor.
All right, thank you very much, Mr. Novak. Attorney Bradel.
Thank you, Your Honor. Your Honor, just some particulars. Mr. Carney's 42 years old, Your Honor. He has 2 children, ages 6 and 8. He was an 11-year veteran of the Dudley Regional School District as a history teacher. And as you know, Mr. Carney now operates several websites and news sites that he engages in very prolifically and provides all sorts of investigative reporting to the public and to his many followers that he has. And I just would note, Judge, that he's got a courtroom full of supporters here who think very highly of him and appreciate very much all of his activism and protest and journalism. So that's his current occupation, Your Honor. With respect to these 2 charges, Judge, this case was the subject of an order from Judge Krupp on the initial bail determination of personal recognizance with no terms whatsoever. Judge Krupp obviously was confronted with the very same issues, the same Norman issues, Como versus Norman issues, and he did not do anything whatsoever with respect to any stay-away orders. In this particular case, Judge, there are complicating factors with respect to what might otherwise be an order in another case. Here you have a journalist who is practicing his craft and is protected by the First Amendment, Judge. And if the court were to adopt the government's request wholesale, there'd be a problem with respect to him being able to cover his choice of topics, which is the Karen Reed murder case. What would happen, Judge, is that anytime any of these witnesses decided to go and attend the Karen Reed murder case, they would essentially have a veto power over Mr. Carney covering the case. So that was raised in front of Judge Krupp, and ultimately, Judge Krupp at the arraignment, not at the bail appeal, but at the arraignment, Judge Krupp erased any restrictions whatsoever.
Mr. Bradel, with respect to the 8 or 9, I think it's 9 with the new indictment, Mr. Novak, witnesses that Mr. Carney is alleged to have intimidated or interfered with, are there any restraining orders in effect?
No, Judge. In fact, 2 of the complainants tried to seek a criminal harassment order in the Stoughton District Court.
I mean a 250-AD?
A 250-AD order, yes, Judge.
Okay.
Thank you. And they were both denied on First Amendment grounds. That was one by Judge O'Malley at the time, one by Judge Walsh.
What about Ms. Gattani, who I understand is the alleged victim in another district court matter?
Yes, that's correct, Your Honor. And
she has a restraining order?
She has a restraining order that's in effect for a year. And in terms of that case, Your Honor, Judge McCallum in the district court set a personal recognizance bail on that case, this new case that we're arraigning now that's been brought to Superior Court. And I know the court's well aware, just the mere fact of an indictment is not a grounds for an increase in bail, just because the government has unilaterally decided to put him in another court. It's the same case. In fact, it's actually a little bit better in the defense category. I provided one of these to the Commonwealth, and it's come to our attention that the complainant who's gone to court and gotten a restraining order saying she's afraid of Mr. Carney, doesn't want any contact with him. This morning at 1:55 a.m., she called him. She should know that he's incarcerated, and obviously he did not speak with her at all because he's incarcerated, but she called him on a Facebook Messenger video call at 1:55 a.m. No one spoke with her. We have custody of his phone, and we've screenshotted and memorialized that call. So this is someone who, on the one hand, is claiming one thing, and incidentally, factually, Judge, every single factual allegation here, Mr. Carney absolutely denies 100%. And in fact, a lot of it is contradicted by the written record that will come to light, and it's been provided in the lower court. The text record where Ms. Gattani contradicts her later statement to the police is contradicted by her text record, where she invites Mr. Carney over. She uses this new case where she's received a subpoena to lure Mr. Carney over, and like moth to a flame, like a journalist to a new set of facts, he went over there to at her invitation to look at everything that had been arrayed against him. Perfectly normal human impulse to go want to see what people are saying about you, and he followed her invitation to go over there. So that's how the facts of that are going to show.
All right. Do you have a copy of that, Mr. Novak?
I did.
All right, Mr. Officer.
A copy of
Thank you. Hold on one moment, Attorney Bradel.
Thank you.
Insanity.
Thank you, Mr. Clerk. All right. Well, as you know, Counselor, sometimes persons who have restraining orders reach out to the persons who are prohibited from contacting them. Your client should be advised that notwithstanding whether or not this individual reaches out to him, he may not, under the terms of that restraining order, communicate with her. Is there anything else that you want to bring to my attention with respect to the bail the Commonwealth seeks and or the conditions of release?
Judge, I just want to note that the new case was personal recognizance with a restraining order already in place. The old case was personal recognizance with no conditions whatsoever. I'm asking you to return Mr. Carney to the status quo. There's no problems. There's no issues. There's never been any problems with violating any court orders. And Mr. Carney just wants to make sure that he doesn't give that the court, he hopes that and respectfully invites the court to not give these witnesses veto power over him being able to investigate the Carney, Reed case, by just virtue of just showing up.
All right. APO Mejia, do I have a carry?
Yes.
Oh, thank you so much.
So we would ask you to return it to the status quo, Your Honor, in all respects.
All right. Thank you.
Thank you.
Mr. Novak, this defendant has no prior, real prior record, correct?
That's correct as far as I know.
And no real indication that he's ever failed to appear to answer charges against him?
I believe that's correct as well.
All right. After having heard argument and understanding in particular that bail is necessary, cash bail is necessary only to ensure the defendant's appearance to answer the charges against him, I will not require a cash bail from Mr. Carney. He will be released on his personal recognizance with no additional conditions. Mr. Carney should be reminded, Mr. Bradel, that if, and he will be formally by Mr. Clerk, that if he is charged with any additional crimes, certainly there will be another revocation period.
Thank you.
Okay? The condition of release on personal recognizance is not committing any additional crimes. Mr. Clerk?
Much appreciated.
Actually, we have one more thing to address, which is, Mr. Bradel, you had filed this motion to strike, motion for remedial orders and sanctions. Is that now moot given my decision with respect to the motion that the Commonwealth had brought?
I don't believe it is, Judge.
Do you intend to press it?
I do intend to press it.
All right.
In fact, I wanted to provide the court, and I'll provide the court on Monday with some of the physical evidence of the result of the behavior.
All right.
So,
well, Mr. Novak,
Okay, so then I just, they're going to have to respond to that. It's over now. I want to fast forward to when Toto Boy does come out of the...
Thank you. Thank you from the bottom of my heart, guys. Thank you to everyone.
Somebody asks him if he was an FBI informant. He gives him the dirtiest look. Anyway, he has a couple words to say, but
Everybody who showed up today, who messaged me on the Securus app at jail, who talked to me on the phone, who donated, who did whatever to just help out. You guys made me feel loved. You made me feel remembered, important. Like, it made me feel that I'm not alone in there. It was a really hard 60 days in there. I'm not going to lie, the longest 60 days of my life. but I just knowing that I had a world of supporters out here to have our back, and that I'm completely innocent, and that you never forgot that. You always stood by me. I can't thank you enough from the bottom of my heart. Both. Are you an FBI informant?
Why?
Why
do you think you're both?
Because I haven't committed any crimes, and I just spent 60 days in jail. I could have gotten out whenever I wanted by taking a plea, but I chose to simply stay in jail because sometimes principles matter more than small sacrifices.
Will you keep doing what you did that got you in this situation? Excuse me? Will you keep doing whatever you did that got you in this situation?
I'm going to keep obeying the law, and I'm going to keep reporting diligently on the camera until we have justice. I don't know anything about them. Why doesn't he edit the video? Anyone else?
Nate, we love you! Thank you, too! Go home and see your kids, Aiden!
This broad just screaming. I should have says this broad and spaghetti. Again, welcome to transparency. Thought we'd start with this because he's mentioned all up in this 301 pages. It's a 25-page motion that I'm going to point out. It's the Commonwealth's opposition to defendant's motion for sanctions and for the disqualification of the Norfolk County District Attorney. I'm going to point out some key things that I think it brings interest to the timeline of events. Let's see.
I don't know anything about that. Why are you an FBI informant? Any real reporters?
Why are you an FBI informant? Right there. That was just like, why are you an FBI informant? So, just wild. And he's like, any other, like right there, that's his face, like, fucking asshole.
What is this person? Hey, where's the Hornet? Thank you, Tim! Where's the Hornet? Aiden! Yeah!
And then Tom, look at Tim. He's like, he just stands there, just letting them do whatever.
Good job, Aiden. Thanks, Timmy.
Long live Turtle Boy!
Turtle Boy, baby.
About it. See what they have, and we'll
You entered that. Aiden, will you jump, Timmy?
Did you know it was?
Why don't you go see Krusty? Get out of
And
here.
it's still great.
I would have had a couple strippers in a limo. Let's
Natty.
Daddy!
Aiden, why was Karen cheating on you?
No. Saw that, right? You good? Yeah. All right.
What's it?
Yeah, we're good.
You okay?
Yeah. That was Grant. You saw Grant?
We heard you guys were inside. Yeah, so you didn't hear all. We heard everything.
Yeah.
We didn't know.
Oh, this is so nice.
All right. Oh my God. Justice! Justice is coming, Aiden! Yeah!
Did he just fall? Oh shit. That was gonna cut off right in.
Everybody is. She's got give it a break.
Hey, they're pushing me. Where are the officers?
Get the fuck out of here.
This man is assaulting me.
You little shit!
Nice to meet you guys too.
Hey,
Nice to meet you
Aiden,
guys.
can I get a quick
Stop
picture?
touching me.
Yeah.
Grant's
Stop
crazy.
touching me.
Love you. You did good, honey.
You're great. I just watched you push Aiden. You're right.
Real violent.
You got it reversed?
What's wrong with your kid?
Welcome home, TV! Freedom feels good!
Taking selfies. Yeah.
Justice is here.
Yes, absolutely. Thank
I'm
you.
gonna
So enjoy your kids, Aiden.
Where are the homeless people, man? Where are the transients? Come on, get Norfolk.
Grant is
Get that
off
in the background.
rocker. Yeah, come on.
Right, where's the bar? Let's go have some drinks.
Shake it.
Oh, come on. I'm sorry. I've been laying on the horse. Get the fuck out of the way.
Buckle up.
Good. Nice to meet you, my friend. Thank you.
Grant, you gotta settle down, buddy.
Grant, you're pressing charges, bud. Pressing charges on you.
Hey,
You sent me
guys,
to the
walk
ground.
away.
Pressing charges on you. I'm on video. You're in trouble.
He's gonna come.
I was hoping someone would. Right now.
Tip!
There's another chase.
Yes. I love it.
Tom,
How are you?
how are you?
Good.
Tim is the paper.
Finally!
So
Finally!
when she said that, let's get it
Well,
out of the
if
way.
you just from the bottom of your stomach, just come right out.
What?
We're gonna hear those
You
other
guys-
things from yesterday, and then we'll.
We already have it. We have our. We're gonna be there. We're gonna be there, and I cannot wait till people watch in this fucking crowd, man. I'm gonna just high five everybody. I'm gonna invite all these turtle riders to come to the bar, and let's see who can really throw down with the queen. Because I don't think Boston's ready for us. So I don't think that they are. I don't even know if I'm ready for myself. But it's right around St. Patrick's Day, so I hope all the taps are already turned green. Okay.
Are we doing pub crawls? Because that's what you do in Boston.
I know I'm pub crawling all day with my fucking camera, live streaming the Karen Reed case. Okay.
Well,
like,
I don't want
I'm gonna
anything
treat it like
anymore.
Georgetown, all right? A couple days I am gonna be in the courthouse, but in the courtroom, but I just don't think I could sit still for like that. And like I want to be, like I could just put Bella up in that bitch. Like, oh, you just take those notes, girl. I want to do a cartwheel down Norfolk Street.
A cartwheel?
Yeah.
Yep. Good. Oh, she's logical.
I like that judge a lot. She's very fair and she's very thorough.
Because there was talk of good.
I'm totally gonna take selfies with Tim.
Hey, Jody.
Look at him.
Hi.
Are those shots? Oh my God, he has shot skis.
Bottom of your stomach, just come right out.
She said, like, we're gonna hear those other things from yesterday, and then we'll talk there. Like,
Yep. Good.
more promising.
Oh,
She's
she's
like,
she's logical.
I like that judge a lot. She's very fair and she's very
The judge.
thorough.
Right here.
Good.
Take a look. Right. Selfies with Tim right there. He's got shot skis. Look at those. What are those? Are those shot skis? Is that what you take shots with? I don't think they are, but they need to be. All right. Damn, look at all this. All,
Hey, brother, huh? On the way now, Monday's a big one.
I know Monday's gonna be great.
Monday's gonna be great. Oh my God. This is like the Super Bowl for these guys. I love it. Oh my God, it is. Okay, I don't know if you guys have ever been to Georgetown, but so I had to go there.
Marky Mark and the Patriots came to town.
My stepsister got married there. So we go down a couple days beforehand and we're trying to hit up like these bars in the area. And I'm like, what the hell? They got CNN blasting. They have all these, everybody's literally at happy hour during the day in these bars. You know how you normally have like football games turned up or like the music turned on. These Georgetownians, whatever you want to call them, Georgetownians, they have CNN blasting, watching hearings. I mean, like picture us like watching. So I'm like, oh my God, we need to take over a bar and watch the Karen Reed case up in a bar. I'm telling you, it was like when I went to Georgetown, I was like, every single bar, there is no playing music. People are blasting court cases, court hearings, and people are like cheering shit on. And I'm just like, this is actually pretty cool.
Only place we need to go is Halfway Cafe.
Yeah, and then I was like, these motherfuckers are such dweebs. I didn't know how I felt. I was totally conflicted.
You were confused.
And I was totally conflicted because I'm like, God, what a bunch of fucking dweebs, losers. And then on the other hand, I'm like, I wanted to see some of the cases, and I'm just like, dude, they're blasting this though. It was every bar was turned up. Like, can you imagine if you took over the jukebox and you started playing? Here I am.
It better be Marky Mark.
Rock me like a
You gotta know your Bostonian.
yeah. All right, guys, let's talk about it. Welcome back to the projector. We'll get serious for about 30 minutes. Keeping this one light because I am live tonight, Idaho 4 style. But prepping, we've been prepping for the case. Okay, so they filed this 25-page motion. Let me just organized it all day, all this morning. So all these exhibits, okay? And but I was paying attention to the timeline, and right here, what began as Attorney Yannetti representing to the Stoughton District Court in February 2022 that the defendant lacked any criminal intent in a motor vehicle accident has spiraled into a national conspiracy theory premised upon the defendant's variety of flawed, unfounded, and sensationalized claims. However, truth is not dictated by the loudest voice. Okay. Now, myself and Bella, we literally all morning, we're going through a ton of exhibits and we're very interested in the Cellbrite data because, now again, remember, this is a motion that they shouldn't be sanctioned, and instead, they're basically saying the defense is completely out of whack. All right. Blown up.
And that happens in cases.
Yeah, they're going to go back and forth. They're going to go back and forth.
But you can't just say willy-nilly stuff also. It's not appropriate.
So I want to point to everybody, because we're going to be fair when we're going to be covering this, as I'm fair in everything I do. If you want a peanut butter and jelly sandwich and I want one, I tell you to make it, you cut it, and I get to pick my half. That's how you make it.
You make it. You cut it.
And then
but I'll pick.
Yeah, because then like
Because you wanted it.
No, it's because that way that's how your mom ever taught you, like, okay, here you go. Like, then I'm gonna go ahead and you're gonna cut the sandwich, and then your sister gets to pick the side, you know. So let's see how fair you are. That's how you do things around here.
That's how you do it.
But so here, let's go ahead, and the first thing to point out is we're gonna dissect. Again, I'll be doing like a marathon with this. We're gonna be they come right out the gate swinging at the ABC News broadcast where Attorney Jackson Yannetti and the defendant sat down for an interview. Now, they said that it was against her bail right here, pointing this out. The defendant's continued attempts to materially prejudice the judicial proceedings and to try the case in the media is unprecedented. Further supporting by the fact that on September 17, 2023, the defendant traveled with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer to the victim's home in violation of her conditions of release, as well as other places of interest in Canton. Yes. So basically, hello, Lana. Hope all is well with you. Yes, I think it's great over here. Hopefully you're all is well too. They cherry picked their findings. Yes, we're going to talk about that. Well, I think both sides are cherry picking their findings, to be completely honest. But it's going to come down to facts, and yes, unprecedented in the that this is being tried in the media. Now, they're basically going a little tit for tit here with saying, I think Karen Reed drove by the victim's home, and that's a violation. So that, I think, is what the violation is. It's so minuscule, but hey, nonetheless, they went ahead and pointed it out. Next thing I want to point out here is all right. So, despite requests made by the Commonwealth on May 9th, so this is going to go all the way back to May 9th, and it's actually, in fact, going to go back to April to me. I like to put everything on a timeline of when things happen. I pay attention to dates and times, and something that caught my attention was that they're able to say that they're able to prove, and this is not a crime though, that Turtle Boy was in contact and talking with A, the defendant, B, Gannetti, and C, then Alan Jackson. Okay. Now, the part that you can't do is if things are being shuffled through to Turtle Boy that weren't supposed to be, like things that would be sealed. If something is sealed, yes, you cannot turn it over. But if something is not sealed, but it's more just like a, God, I hope he wouldn't show that. Like, let's say like an autopsy photo. Okay. So you have to really like focus in on what's truly happening, because bottom line, the Commonwealth's going hard at the defense saying, you guys basically used Turtle Boy for your agenda. Okay. And why this motion is 301 pages is because all of it except for 25 pages are exhibits. So 25 pages is the motion, and then 276 are exhibits. Everything that mostly we've seen before, except some new stuff. There are some new things in here that I haven't seen. And we do a pretty good job of getting our hands on stuff. We have no problem making our own requests. That's what we do. So for the most part in this case, every document that's out there, myself or Bella has seen. When we were reviewing this document, so despite requests made by the Commonwealth on May 9, 2023 and October 12, 2023, so the Commonwealth was attempting to try to contact the the Attorney General's office, right? And it wasn't until January 16th, 2024 that an assistant U.S. attorney, not familiar or involved with the investigation, contacted both then Commonwealth and the defense counsels, Jackson and Yannetti, to discuss the possibility of disclosing information in the possession of the Department of Justice pursuant to federal regulations. Now, in order to understand what's going on here, you actually have to go further within these exhibits to understand that the Commonwealth is basically putting the blame on the defense, saying, listen, there's this big probe because you all went to the Attorney General's office and said, we're filing a complaint. We want this investigated. We want to bring in the feds. Okay. And it's kind of funny that that guy said to him, Turtle Boy, on the steps there, you're an FBI informant. That's funny to me because of two reasons. Do I think he's an informant? Like, no. But do I think that 100, they were like, this is corruption and we need to go, we need to go above. You can't take corruption to the county that's corrupting you and think that they're going to do something about it, right? We have to go a different route in order to get that looked at if there is in fact corruption. Now, in this motion, as of February 15th, 2024, there was 2 grand juries, okay? One was a federal grand jury. The other was obviously the grand jury that indicted Karen Reed, okay? Now, what ended up happening is that people from the grand jury, the 40-some witnesses that testified in the Karen Reed case for the grand jury, they then were starting to get subpoenaed for the federal grand jury, which was the investigation within the investigation, okay? What's interesting to me is Ted Daniels gets involved, okay? You guys know Ted Daniels, Boston, was it Boston 25? Journalist. Okay, so we're going to get to that. Now, what the Commonwealth is saying here is that we haven't gotten anything when it comes to that. As of February 15th, the Commonwealth has not received any grand jury minutes, reports, exculpatory, inculpatory, and we've received nothing about the investigation conducted by the U.S. Attorney's Office, although it has made repeated requests. So they've asked us for stuff. We've given them stuff. They haven't given us anything. They're making this known. So, and it says see Exhibit R, which is an email. Okay. We're going to get to those emails because they are important. Now, remember when Unetti stood up and he said we were contacted? That's that email where both parties were contacted. The Commonwealth and the defendant anticipate both parties receiving privileged and protected materials from the U.S. Attorney's Office within the next week. Okay. Now, the Commonwealth has diligently investigated the defendant's unsubstantiated allegations of police and prosecutorial misconduct. So, once Unetti and Alan Jackson, Little, her whole team, the defendant, even Turtle Boy, they're saying that the Commonwealth has taken everything that you brought our way and we have investigated it, okay? They've done efforts, so they're saying here is efforts to disprove the defendant's allegations have included interviewing additional witnesses, submitting evidence to a veterinarian forensic laboratory that concluded that there was no canine DNA associated with the swabs taken from the victim's clothing area. The voluntary submission of law enforcement officers' DNA profiles to conduct comparative analysis. Now, this is what I underlined it already because this is all I care about. And this is what all of you guys should care about because we want to talk facts. You want the evidence. I conducted my own, and I stand by my work. I conducted my own. I took all of the material that we were able to obtain from the cell brights that were put out there. Maybe they weren't supposed to be out there, but we got our hands on it. And then I put together an extensive timeline based on the digital footprints of Jennifer McCabe, but most importantly, John O'Keefe. That was who I was focused on because I was focused on his phone's movements. Okay. Now, they did extensive GPS analysis of the victim's phones, physical locations at various points, and the hiring of 2 independent forensic examiners, one of which is the senior digital intelligence expert from Cellbrite. to explain how the defendant's supposed expert misinterpreted the Cellbrite data from Jennifer McCabe's cell phone records. Okay. Confirming that the internet searches for how long to die in cold and how long to die in cold were definitively conducted at 6:23 a.m. and 6:24 a.m. I'm not disputing that. I'm not disputing that she Googled that then. The question is for me is, did she Google it though additionally at 2 whatever time it was on my spreadsheet? I put it all out there for you guys. It's on a different episode. And we said to ourselves, myself and Bella, we were sitting at lunch. We've done it a couple different times to talk about how in the world could you mistake something like that? Like, and I'm like, wow, this is a total call. This is a total question for Michael or Micah Sturgis right here. This is totally him. And, you know, could it be something that this, no way could they think it was just still in like UTC time or something. But that to me, I'm leaving it right here. That to me, this is going to be, I'm intrigued by this. I'm intrigued that they went ahead and put it in writing and saying that they spoke to the senior digital intelligence expert from Cellbrite to explain how the defendant's supposed experts misinterpreted the Cellbrite data. You understand that? Okay. So, because the big thing here is that Jennifer McCabe, her Google search, right? Now I have it as it's a deleted entry that she deleted that. She deleted the 911 call. Okay. This woman deleted a ton of shit. So, so we're interested in that. Now the thing that I can also show, and I said this on my show, I said they really need to focus on John O'Keefe's phone movements once they arrive, once Karen and the 2 girls arrive, Jennifer McCabe being one of them. You really need to look at the phone movements, because that to me, let's say you throw out all of this. Okay, let's say that Jennifer McCabe did not Google it earlier. What you can still lean on, okay, is that John O'Keefe's phone, without a doubt, was literally running all over the place as soon as they got and touched down on that property. And you compare them to the movements of Jennifer McCabe and where she was walking and where John O'Keefe's phone was going, and she's passing it off. That's the part, and the only reason I don't interject myself in shit, but I thought that my work was good enough to prove that phone was being. Why would you go and pick up somebody's phone? The first thing that you should be doing is you shouldn't be touching anything. And if there's cops right there, like, you let them do and grab whatever. Once I found out that people were trying to say that all of those steps was due to doing CPR, I said, get the fuck out of here. I said, get the fuck out of here. The most important thing being this. If John got hit by a car and was just, he just laid there, right? And that's the last movement. Then how are you getting 3 flights of stairs? How is he getting 3 flights of stairs if he got hit by a car? You had to go inside the house, right? Okay. So that data alone tells me that everybody that's saying John O'Keefe, he was never in here, we didn't see him. You're going to have to explain how, if y'all put an imaginary or reeled out some Stairmaster, and that John O'Keefe just gets out a Stairmaster and starts doing stairs or some shit like that. But his phone, it was one thing to see the steps. It's another thing to see you're physically going up a flight of stairs, not once, not twice, but 3 times. So,
and you're gonna have to explain it in trial with Alan Jackson asking you the questions, and he's amazing when it comes to cell phones. And as a litigator, he understands.
Yeah, if you have a really good timeline, yeah. So, but moving on from that, because we've talked enough about it, but I highlighted here because I was very, very interested in the fact that they're basically saying the defense's expert fucked up. And you got to be fair on both sides, and you have to look at that. So I'm interested in that, especially who's saying that they fucked up. And that's somebody who's the senior director of Celebrate. I mean, come on. So now moving on. The defendant also alleges that the Commonwealth improperly released information about the federal grand jury in November of 2023 to the media in response to a public records request. The Commonwealth denied a public request at the federal rules of criminal procedure and federal case law. See Exhibit N, the federal crim P. Yep. So is it in here? Yeah. So I want to show you guys what Exhibit N is, because this is the good stuff. Okay. All right. Now, hold on one second. How do I want to do this? That's fine. Ted Daniels reaches out to Norfolk, and he wants a he's asking for a just like a FOIA. He just wants a public. Here's my request. But we were interested because we're like, who the fuck is this, and who the fuck is this? Okay, so obviously we went ahead and we Googled their names, right? And we come to find out that this woman here was and worked for the Norfolk District Attorney's Office, okay? And in the beginning stages of her career, that's when she was there. She marries this guy, by the way, Dustin. So we got Laura Greenberg, that's why it is hyphenated. She marries Dustin. I don't know if it's Chow. I don't know if it's... So... Well, Dustin is a federal. Dusty Pooh is a federal prosecutor. Okay, federal prosecutor. Now, so Ted Daniels sticks his big old schlong in the mashed potatoes because he's like, I want to. It's Chow, Lana. It's just Chow. Thanks, Snatch. So it's from a BC Boys song, by the way, about the mashed potatoes. But here, Ted Daniels does and goes for these people's. He wants any letters pertaining to or about anything. One letter was identified and is being withheld from public. So when we go back to here, this is all about Ted Daniels going for this FOIA request. And then it gets answered down the road as to why they wanted this FOIA request. And they wanted this FOIA request because of the letter that Morrissey puts out in November of 2023. Or I'm sorry, in May 2023. He puts out a letter, and it is it's here. It explains what the hell was going on with everything. But I'm gonna get there in a second because I want to just stay in order with how I said I wanted to do this. Basically, that letter is really important because in May of 2023, that's when the rumors and stuff started floating around that, hey, there's an investigation within an investigation. We're basically investigating the witnesses, okay, and who could also be the police. So we're investigating the people. There's 40 people that testified at that grand jury, and that's how this starts getting made public to the DA, okay? And in fact, here it is. May 18th, this is a letter. We'll just go straight to it, and then I'll just reroute how I wanted to do it. Fuck it. Let me make it bigger for you guys. All right, this letter is basically the DA saying, hey, we need you to come in and we want a private or a special prosecutor, who's ever doing stuff with the Attorney General's office, because of the following reasons. So I write formally to request that an ongoing investigation being conducted by the United States Attorney's Office for the District of Massachusetts be examined by the Office of Professional Responsibility. The facts and evidence gathered included more than 40 individuals testifying before the Norfolk County Grand Jury, led to the second-degree murder indictment of Karen Reed. Reed was the operator of the vehicle that the evidence demonstrates struck her boyfriend, Boston police officer John O'Keefe. O'Keefe was then left to die in the snow. All right. Then the defendant, through counsel, has been raising suspicious issues of a third-party culprit and complaints of witnesses or witness and police misconduct as they attempt to confuse by offering not different interpretations of Commonwealth statements, evidence, and positions, but inventing them. Okay?
Like accusation.
Yes.
But
Approximately 3 weeks ago, multiple state witnesses who have been brought before the state grand jury notified the Norfolk District Attorney's Office that they were contacted by the FBI. Okay? They were contacted by the FBI. Hold on. Hold on. Okay. And they received these subpoenas to appear before the federal grand jury. Shortly after those notifications to the Norfolk District Attorney's Office, this is who the first assistant in the Boston office of the United States Attorney's Office contacted Norfolk First Assistant District Attorney Lynn to suggest that they were conducting an investigation that may involve a number of witnesses in the Commonwealth First Reed murder case. At that time, Attorney Beeland expressed some concerns about both the jurisdiction and the timing of any actions being taken against with like the United States Attorney's Office, as they could importunately impact the ongoing murder prosecution of Karen Reed. Based on the collective experience of several of my colleagues, it appears to be unprecedented for the federal government to step into the middle of an ongoing state murder prosecution prompted only by inflammatory and ethical dubious defense strategy. Now, we're going to go to the most important parts here, which is right here. They had a call. So since this call was, and it was about saying, hey, you know that anything that you guys are doing in discovery, we're going to have to turn over to the defense. So like, be cognizant of that. So that's what this is about. So it's in the conversation with First Assistant Norfolk District Attorney Lynn Beeland, it was to talk about reminding AUSA Joshua Levy that any statements and or testimony taken in such an investigation that pertain to any of the witnesses in the ongoing state murder trial may create an ongoing obligation for the state prosecutors to provide defense with access to all information and statements gathered or recorded as a result of the federal investigation. The United States Attorney's Office offered the opinion that you can't turn over information that you don't have. Now, was that like code for we just won't give you it? Anyways, just muddying the waters here. But if you read on, the DA right here is accusing that Since the call concluded, we have confirmed that witnesses have testified before the grand jury. Okay. Information may be provided to all counsel, including those not before the federal grand jury. Recent court filings and statements by defense counsel in the Reed matter suggest that defense attorneys were the source of the initial complaint and allegations prompting this action by the U.S. Attorney's Office. And so if you continue to read, what the DA is then suggesting is that this was retaliatory in nature due to the fact of none other than Ted Daniels' two names that he brought up, which is, Laura Greenberg, who used to work for them, and there was a big blowout, right? And then her hubby Pooh, Dusty Pooh, is a big federal prosecutor, and he is in charge of none other than the corruption division, and that he is basically a piranha on them because you fucked over my wife back in the day. I told you I'd be back to get that ass. That's what they're alleging basically is going on. And the way I say it is that you can't have it both ways. So I'm agreeing that bring in a completely unbiased person to do all of this. So I think that that's how it should be. Again, I think everything's gonna, settle when it settles. But I think the truth is gonna come out because if you go off of timelines are timelines, right? So I don't think that he's wrong here to say, like, listen, you guys are the ones accusing us of being, in cahoots. Well, hey, hold on a second. At this next level, y'all are in cahoots, and it's for reasons. Because why are you doing this in the middle of this? Like, can it be something that happens like, afterwards, or But and needless to say, this started in May. Now, we're gonna come back to this here in just a second, because this letter goes on. Right here. This is what Ted Daniels was looking for. He wants this letter. Back, he was saying, he's talking about this old case, okay? And here it is. During this period, AUSA Dustin Chow, without nexus to that prosecution, asked a Massachusetts state police detective involved in the matter if he had any kind of damaging information on the district attorney, first assistant, or the Norfolk district attorney's office. And if you read up before all this, it's talking about Sugar Tits, Laura, and her involvement back in the day with that, with the Norfolk district attorney's office. Needless to say, it's one big cluster, completely convoluted mess that you have here. So let's go ahead and do this, though. To unmess it up, I wanted to do just timelines. Okay. You down with LPP? Yeah, you know me. Okay. P. Okay. Sorry, guys. Trying to keep this all like together has been. Woo. All right, let's look at this then. Now, also what that letter kind of implies is that the people that are leaking stuff from the federal grand jury, we're not even the ones working with them. They're not talking to the Commonwealth. They're talking to the defense, basically. And all they want to say here is that, hey, we're making it known is that the Commonwealth did not release any information or correspondence with the U.S. Attorney's Office until after this court vacated a protective order on January 23rd, 2024. So there was a protective order. It was vacated. So that's why in this motion, there's all of these letters. These letters are in this motion as exhibits. And the reason that they can be, and it's unsealed for us to see is because of that protective order being lifted January 23rd. Otherwise, some of this stuff and the good stuff would not, like these letters back and forth from
Morrissey.
yeah, him,
The FBI.
yeah, everybody, FBI, Attorney General's office, all of this shit. That's the goods, or like the last 6 exhibits in here. They're the letters. Now, we have to, this is how I look at something, is that this is all interesting to me, but the jury is never going to see stuff like this, okay? And, but what a jury is going to see is they're going to see timelines. And I want to point out that what they're saying is Attorney Alan Jackson, Attorney David Yannetti, and the defendant have knowingly engaged in conduct to undermine the integrity of the judicial proceedings, and the Commonwealth requests that this court revisit whether there should be an order as to prohibit extrajudicial statements to protect the right of a fair trial for all parties. Now we're getting close to, like, obviously trial date, right? So what they went ahead and did is the defendant's tactical decision to allege wrongdoings by the Commonwealth is conveniently premised on the defendant and counsel's own misconduct and ethical violations. It is now evident there are numerous false statements made by defense counsel, including those contained within this motion for disqualification and previously filed defense motions that were knowingly made to deceive this court and undermine the integrity of the judicial proceedings. Profound words until we get here, and I was wanting to point this out. Following an investigation conducted by a special prosecutor, the Commonwealth has recently learned that for months, the defendant, Attorney Alan Jackson, and Attorney David Yannetti have secretly conspired to perpetrate fraud upon the court through reckless mistrust, deceit, and hiding behind a social media blogger who has been criminally charged with intimidation of witnesses to direct and encourage the harassment of those witnesses. Now, this is how the prosecution, again, they're picking through, there's so much in discovery, right? So Yannetti and Alan Jackson put together a really, really good, brief. Here, this is the state, okay? Now, let's see if we think that it's bullshit or not, okay? In the defendant's motion to disqualify, which has not been released, or if it has, and if somebody has it, please email it to me because we can't find that anywhere. We believe it's under seal. So now this is what the state's saying. In the defendant's motion to disqualify and sanction the district attorney's office, the defendant attempts to disassociate herself from Mr. Aidan Kearney, the man she now calls an intimidator, who used his website, TV Daily News, Turtle Boy Live, YouTube page, and associated social media accounts to perpetually intimidate and harass witnesses expected to testify as part of the Commonwealth's case against the defendant. Again, see defendant motion for sanctions and disqualification. Again, we don't have that. However, for months, the defendant and counsel have engaged in a concerted effort to use Mr. Kearney as a literal bullhorn. Bullhorn Betty, move over. To say what they could not and to disseminate information and opinions counsel knows will have a substantial likelihood of materially prejudicing the proceedings. Now, take a look. While the defendant struggles to use the Professional Codes of Conduct, 3.6, sword against the Commonwealth, the rules of professional conduct also apply to defense counsel, including Attorney Jackson, who is not licensed. They talk about how he's pro hack vice, yes. Following an investigation conducted by a special prosecutor, Aiden Kearney was indicted 16 charges. I believe that he only has 9, but whatever. Related to intimidation, harassment, blah, 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 blah. So that you see his docket. That's in the small footnotes. Now, I pay attention to the timeline. So their timeline wants us to start with April 17th. Okay. So as demonstrated by the search warrants generated as part of the special prosecutor's investigation. Now that is in here at Exhibit A and B, and it's extensive. And so we highlighted the pages that actually matter and the parts that matter. But on April 17th, the defendant took deliberate action to start sharing defense theories, privileged materials, and evidence with Mr. Kearney through an out-of-state, and this is a girl that Karen Reed used to know in high school, but then they dropped out of contact, whatever. See Exhibit B, which is a search warrant affidavit in Massachusetts. That's how they got the phones. Okay. The next day, so they're using, so like my Excel spreadsheet starts with the state talking about April 17th. Then the next date they want to throw in there, okay, is April 18th of 2023. And it says that the next day, April 18th, Mr. Kearney posted his first story in support of the defendant entitled Canton Cover-Up Part 1. Yeah, that's her. Yeah, that's her. So you guys know the number that he's on right now is like 291 or 200 and something like that. So the first one was on April 18th, 2023. Now, back in 2022, there was a gentleman that approached Yannetti and said
first approached Karen, right?
Yeah, well, I'm sorry. First approached Karen Reed, okay, through Facebook, and his name is Steve Scanlon, and he is a private investigator. He approached Karen through Facebook, and we're going to get to that part because I think that is probably the most important part of this motion. And why when they went ahead and prosecuted him for wiretapping, did they ever say who the person was that he did that to?
I didn't watch it.
Because this is the big wiretapping thing.
I'm guessing this is he told on himself right here like he always does, but
yeah. So here we go. I want to show you guys though. So April 17th, then we have April 9th or 18th. So that's the first ever episode that's talking about the Canton cover-up. All right. So hold on. Now. Okay. The defendant had instructed this Natalie woman to communicate with her through the Signal messaging application, explaining that it provides secure end-to-end encryption, and instructed that's her name's Natalie, to forward all information, which included witness information, home addresses, grand jury minutes. And again, remember, I want to know which grand jury minutes, the autopsy photos, and generally every piece of evidence that the Commonwealth provides to defense counsel, and they pass it on to Mr. Kearney. See Exhibit B at paragraph 44 through 45 and 54. We went and we looked at that. The defendant would put disclaimers or derivatives on certain pieces of evidence, such as, meaning like Karen Reed saying, do not share, urgent, do not publish anything from this report, and make it clear Mr. Kearney, didn't just get it from us, but don't show the exhibits, just read them. Please tell him not to share the title. It has Yannetti's initials, referring to attorney David R. Yannetti. Now, this is only going to be a problem. It depends on what's under seal. I'm just curious of what grand jury minutes. Now, Karen can talk to whoever she wants to talk to. Okay, she can. So take a look here, though. So the next dates that they want to talk about. And remember, I can never get dates ever out of prosecutors here. And so they're bringing us some dates, all right? So here they say December 21st of 2023. Or I'm sorry, June to December 21st, 2023, okay? Between those two dates. Now, that's going to be important because April and May is when the conversations were had. So there's 189 phone calls between Karen Reed and Turtle Boy, talking about 40 hours, okay? But here, the more pressing for me is when they then talk about these call details, which is Mr. Kearney at least 29 times, and that would be Attorney Yannetti and Attorney Jackson communicated with Mr. Kearney at least 29 times. Now, I circled that for a reason because 29, it's associated with. So these are numbers, okay? These would be phone numbers that were associated with, because then I believe with their personal cell phones, it would be 9 and 3. So Yannetti's phone number had 9 calls, okay, and Alan Jackson's phone number. So I'm guessing how I looked at this would be 29 between any number that's associated with their office. And then of those 29, 9 are with his cell, 3 are with his, or are these additional? So again, let's check out that wording, which is, now take a look at the dates. So call detail records from Mr. Kearney's phone also revealed that phone numbers associated with Attorney Yannetti and Attorney Jackson communicated with Mr. Kearney at least 29 times. Now, I'm willing to bet that those were not actually with either one of them. That's my bet. When you're going to talk to one of them, I just believe that the way things are happening now, these guys are on the go so much that there's just a lot that's happening with your cell phone. So, but look at the dates here, April 20th to May 2nd. And see back over here, Karen Reed was the whole June to December. So here, this was April 20th, May 2nd. Now, same thing with these 9 calls, 3 calls. The Commonwealth has a good faith belief. That means there's no evidence, by the way, when you say stuff like that. They don't physically have it, but they have a good faith belief that these conversations continued even after Mr. Kearney was criminally charged in October of 2023. Okay? Everybody must be using burner phones. But what happens in the dark, they say, always comes to light. All right? Again, I want to pay attention to those dates. Now, in May 3rd, they come out down the stairs after a hearing, and Jackson says, "Don't you want to ask some questions?" Then proceeds to point directly at Kearney, saying, "I know you do." To which Kearney says, and ecstatically in response, "I have been." Okay, so they want to throw that in there, none of that's okay. When the Commonwealth referenced this incident in June of 2023 as an example of an inflammatory extrajudicial statement, the defendant criticized the Commonwealth and called this an absurd characterization of what Attorney Jackson actually said. See the exhibit. What the Commonwealth now knows is that it is not what Attorney Jackson said, but what he did not say that is so troubling. Prior to making that derivative, Attorney Jackson, Attorney Yannetti, and the defendant had all communicated with Mr. Kearney and provided him, so remember that date of May 3rd. Remember they started talking, they said April 20th, and they said to May. So incident happened on May 3rd on the court steps, okay? So they communicated with Kearney and provided him non-public materials, theories of defense, and other pieces of evidence that enabled Mr. Kearney to harass and intimidate witnesses.
There lies the problem. Because you can talk to whoever you want with your Karen, and you have the best attorney, in my opinion, in the United States representing you, which is Alan Jackson. The guy is a beast. If you don't know about it, he's amazing. He was the DA in Los Angeles.
Yeah.
Like he's been a prosecutor.
When you have one of the best, like, why even fuck around? Okay, like.
So that's where the problem is, in my opinion, Emily, is.
Now, what they're saying is that those efforts were encouraged and celebrated by Jackson and everybody immediately following, because then they are saying that they all went out to lunch together at the Boston Seaport. Now,
where they eat legal?
I don't know. They went to the Boston Seaport, Exhibit B, paragraph 53. I'll tell you all about it. Now, none of that, though, is illegal to do and to have lunch with him. But the parts that would be is if there's stuff that's sealed and you're giving it out, you can't do that. Okay? So they're going to have to prove that sealed material went out. And if it did, I don't, yeah, that's bullshit. Fuck that. You can't do that shit, you know? So a clear inference can be made that the defendant and her counsel directly encouraged and manipulated Mr. Kearney. So now they manipulated Mr. Kearney to continue personal attacks on witnesses and their family members.
I don't think anyone can.
I don't think anybody needs to manipulate that man. He does whatever the fuck he wants now. So they're basically saying, here, if we're going to be disqualifying people, or we're going to be, you know, slapping people around with, you know, sanctions, let's take a big look at this. Okay. Now, when you're going to use words like this, likewise, the defendant claimed that she had been materially prejudiced by the Commonwealth's deliberate misrepresentation and deliberate withholding of exculpatory information known to it about a federal investigation regarding its witnesses is highly disingenuous and utterly deceptive. See defendant motion for sanctions and disqualification. Again, we don't have that. The evidence now shows that the defendant and her counsel have known about and shared detailed information about a federal grand jury investigation as early as April 13th, 2023. Now, this would be before Aiden ever started covering the Karen Reed case, according to this date. Yeah, because the Canton cover-up, remember, we're gonna go back. You guys can see the date that they wanted to give this is, yeah, April 17th and April 18th was the first one. So here, oopsies. And publicly revealed the existence of a federal grand jury in court on May 3rd, 2023. That is when I believe, is that when Yannetti said, oh, Morrissey, he knows damn well who's being investigated. Is that when is that the court hearing that he made that comment?
I have no idea when Yannetti did that comment. Could be, we should look into that.
But saying that in court and that being the way that it got leaked isn't a problem. Also, it's not about it. What they're trying to say here is that they were given the grand jury minutes of the federal grand jury minutes. And the state saying we've never even had those. We still don't even have those. Okay. So the defendant and defense counsel's knowledge about a federal investigation both predicates and exceeds that of the Commonwealth. Commonwealth is basically saying they are in the fucking dark, okay? Because the Commonwealth, the Attorney General's office was not communicating with the Commonwealth at all. They just simply would ask them when they needed stuff, and they would turn it over. Okay, that's all that was happening. But in May, remember these times, and so that comes out in May, right? When Yannetti makes that comment, like, you know damn well you're being investigated, basically, or he knows he knows who's being investigated. Now think about the May 18th letter. Okay, May 18th letter. So when you're actually putting this all on a timeline of events, like this shit was happening way back then. Okay, but it was the defense that got the attorney general's office and the feds to do anything. But they're saying how they were able to do this, how the defense was able to do this, is because of fucking that Dusty Poo and Laura situation, that he's in charge of it, and that's why they've come with such a hard-on for his this district, because of their personal conflict, or her personal conflict with the district back 12 years ago. Yeah. So when I said this is so like intertwined and muddled between, it's just convoluted. It's convoluted from both ends. And, but you have to remember, there has been no gag. Okay. There's been no gag order.
They've been closed.
Yeah, they've been closed. The state's been asking, like, please, can we gag? Can we gag? And here, good old, what's her, good old Bev.
Auntie Bev.
She's just been, no, denying that, like denying those motions.
And maybe not. But Alan Jackson is a very experienced attorney. He's not going to ignore a gag or when they're close to a gag.
Okay, so let's go ahead, and then I want to show you guys then where, okay, so basically here, in the defense opposition to the Commonwealth's motion to prohibit extrajudicial statements that would be prejudicial, the defendant writes, it had indeed been publicly reported that a federal grand jury had been impaneled. So in their motion, which the defense filed, saying that it was publicly known that there was this federal grand jury that had been impaneled. Guess what they say, though? There is a marked difference between stating that something has been reported and revealing something that was previously known or unknown to anyone. This was not the defense revealing publicly that a federal grand jury had been impaneled, something about which the defense team would have no knowledge. Instead, as Attorney Jackson stated at the May 3rd, 2023 hearing, this was Ms. Reed's counsel reiterating what had been publicly reported. Emphasis added with what's been publicly reported. See Exhibit G. These statements are profoundly false, because what they are saying is that, yeah, you fucking gave what the state is saying is that, yeah, it's been publicly reported because the defense gave this information
because of you guys
to fucking Turtle Boy, who then publicly reported, and then you guys said, oh, it's been publicly reported. That's what they're alleging here. Thank you. We pride ourselves over here at TNT. Dynamite. So this trial is going to be literally, you want to talk about a dog match? This is going to be a dog fight. We have people that do not like each other. Both sides, We have, I'm sorry, like I think Karen Reed, in the past couple times that I've seen her in court, I'll go ahead and say it, I think she's come across as very smug and arrogant, and I hope that she is being talked to by her defense team to tailor that behavior. I know that I can be a very,
how are you going to say it? What are you?
I'm Italian. I use my hands. You're going to have to, you have a jury there, okay? You're going to have to, those people are deciding your shit. You have the best of the best in representation, okay? And, you know, I just, silence is more. So I think that she just really, she cannot come across, and we're over here debating, do we think that Karen Reed is going to take the stand? Karen Reed's openly talked about the case with, I guess say like news outlets or, you know.
Nightline.
Yeah. So what do we think? Do we think Karen Reed's going to take the stand? Right now, I don't think Karen Reed needs to take the stand, but I don't know.
In my opinion, I do not think she. When you have an attorney like Alan Jackson, you're not taking a stand. That's all I got to say about it.
Mm-hmm.
And you could tell I'm a fan girl. Like I love.
But do you think that Alan Jackson thinks is maybe in the best? Is just that like
never?
Because she thinks she's the one that can tell her side of the story.
Do not think that.
I don't think it's needed. We'll see. Now, prior to Attorney Jackson's statements, the existence of a federal grand jury had not been widely publicized and was in fact something the defendant and her counsel had utmost knowledge of. Okay. The only source to support the defendant's claim for the existence of a publicized federal grand jury was one footnote to TV Daily News, a post authored by Aiden Kearney. See Exhibit G, Exhibit K. In this April 20th, 2023 post, now remember the timelines, and we have all about this, April 20th, that's when they say that conversations began between Yannetti, Jackson, and Kearney. They used April 20th to May, what's the date? I think they just put May, they don't give a date in May. So in this April 20, 2023 post, Mr. Kearney first announced on Turtle Boy Daily News, breaking news. According to reliable sources close to the matter, a federal grand jury has subpoenaed multiple witnesses who were in the home of Boston police officer Brian Albert on the night fellow BPD officer John O'Keefe was killed. The only individual who I can confirm with 100% certainty has received a subpoena in hand is Jennifer McCabe. Again. Okay. FBI visits, basement floor reportedly replaced. Remember all that talk? Notably, call detail records produced in Mr. Kearney's case, like in his separate case. Okay, so this is how they got creative, and people can say, like, I think that they're going to be making some huge arguments during trial, what's going to be admissible and what's not in Karen Reed's case when it comes to Homeboy. What do you think?
100%, but in my opinion, I'm just going to say it. This should never happen because it muddies the waters.
100%.
And it undermines the hard work of the defense attorneys and all of the money that Karen Reed has spent and people, you know, the time that those defense attorneys have put in and even the prosecution has put in because you just, you know, I mean, it's not necessary.
So right here, this notably call detail records produced in Mr. Kearney's case reveal that Mr. Kearney spoke with phone numbers associated with both of those attorneys on April 20th. That's how they're taking and making this that's circumstantial. Okay, it's circumstantial to say that, hey, he talked to, you know, Kearney talked to both of their offices on the same day that he writes the April 20th, you know, breaking news. All right. And then on May 3rd, that's when Alan Jackson says the words that this has been publicly reported on, you know. And what the state is saying is like, yeah, because you gave him this information. My question would be is, how did Yannetti and Jackson know that? So you're saying they had FBI intel? Because Jennifer Coffindaffer had, I mean, she's the one with the intel here.
I think it's taken out of context in my personal opinion. I think they did talk. I don't think that there's necessarily proof that Alan Jackson or his team or anybody gave him that information on Jen McCabe. They might have given him other information because he's not an idiot. Like, I can't stress that enough. Alan Jackson's not an idiot. He would know there's certain things he can't tell this guy. So I think that it just so happens that after he talked to the firm,
we're just showing how they're trying to connect their dots when they're saying what they're saying. They're using it's circumstantial that hey, we can say this because those two, that was the first time that they talked, and look at this is what he posted. Now I have a question, all of you guys that are Turtle Riders. There's no way that Turtle Boy just started talking about this on the Canton cover-up #1. I was under the impression that he was talking about it before that, and that he just started labeling those episodes that. But there was stuff that he was reporting on before that. Correct me if I'm wrong. Let me know, because I think that would be a play on words with this production here, what the state has produced by saying that the Canton cover-up episode 1 is like the first one. I'm questioning that, because I thought that I was under the impression that Aiden was covering this way before April of 2023. So, which would like blow this kind of timeline out of the water, meaning in a defense positive way for Karen Reed. So they say a clear inference should be drawn that Attorney Yannetti and Attorney Jackson were the reliable sources that disclosed the existence of a federal grand jury. And again, let's say that they were, but how would Jackson and Yannetti know that? If you think about it, unless Jackson and Yannetti were called to testify, how would they know that? So the feds are telling those two that? Or is it more plausible that somebody that did 100% get a subpoena from the feds told that to Aiden, and Aiden told that to Yannetti?
100%. I think that's what it is.
You see what I'm saying?
I think that's exactly what it is. It's blown out of proportion.
Oh, wow. So really? Interesting. Thanks, H-Back. You're always just full of fucking H-Back.
Oh my God, H-Back's in?
Oh, anytime I talk about Karen Reed, H-Back is just riding it. I'm going to get H-Back a hoodie that says, riding these titties till I die. True transparency. Okay, so perfect. Good. Awesome. But how I envision what transpired here, though, is that there may have been a conversation on April 20th, 2023, and how active Turtle Boy is, I believe it would be him writing them to say one of the witnesses, showed me their subpoena. Anyways, now, remember timelines I'm all about them. Here we go. On April 23rd, 2023, through her friend, the defendant sent a follow-up to Mr. Kearney. Not public. The feds have been involved longer than anyone is likely guessing. So April 23rd, so April 20th, he posts that. Now, April 23rd, through her, so Turtle Boy was talking to Natalie, okay? And the defendant sent a follow-up message to Mr. Kearney saying, not public, the feds have been involved longer than anyone is likely guessing. And on April 28, 2023, the defendant expressed frustration as to why Mr. Kearney was not referencing the federal investigation more in his postings, and offered additional information emphasizing that it's the U.S. Attorney's Office. They don't shoot and miss. They have a case and way more evidence than we do. So remember now, the way that this whole motion started off with was, hey, Yannetti in February of 2022 said just one sentence, which was, hey, what began as Attorney Yannetti representing to the Stoughton District Court in February of 2022 that the defendant lacked any criminal intent in a motor vehicle accident has spiraled into a national conspiracy theory premised upon the defendant's variety of flawed, unfounded, and sensationalized claims. However, truth is not dictated by the loudest voice. So now, okay. They don't just shoot and miss. And way more evidence than we do. I know this for a fact. Jen McCabe testifies this coming week. I'm not sure about the others. So how in the world would Karen Reed know that? Okay, just think about that. And if someone told that to Karen Reed and Karen Reed's telling that to Turtle Boy, how is that a crime? I want to know how Karen Reed knows this. Okay, and they could possibly say, oh, well, her attorneys told her. So then, and then she told, Aiden. Well, once again, how did her attorneys know? That's attorney-client privilege. I mean, anything they talk about is client-attorney privilege. Now, they're also going to probably say that, well, the only person that could kind of waive that would be Karen Reed if she wants to waive her client-attorney privilege, but I don't think we're ever going to know that. Okay? So, what I see here is, and again, I'm upset and I'm pissed because this is a motion that they're responding to. Where I want to see that motion, but it's sealed. It's fucking sealed. It'll be unsealed, but it's sealed right now. Now, on April 28, 2023, the defendant subsequently informed Mr. Kearney that the DA office has been informed that is confirmed 1,000%. On May 5th, 2023, Mr. Kearney contacted the defendant about a rumor that the FBI agents were in Canton. Like, I cannot believe he puts any of this shit in his motion. Right here, none of this should be in there. Right? And then 2 days later, the defendant confirmed a communication with the U.S. Attorney's Office about the investigation, responding to Mr. Kearney, not public. Levy, remember, this is this Levy guy, confirmed no swarms of FBI were in Canton 2 days ago. See Exhibit B at paragraph 60. Now, the defendant has then boasted that acting U.S. Attorney Joshua Levy, does it go by Levy, you think?
Levy.
You think it's Levy?
Yes, it is.
Doesn't typically prosecute. Like, he never prosecutes. He just delegates the assistants with the division. But he's running this G grand jury. Okay. Now, Mr. Kearney openly discussed his knowledge that the defendant was interviewed by federal law enforcement and that the defendant, okay, so this is how Karen Reed is saying. So remember what I've been asking is, how does Karen Reed know about anything? Well, Mr. Kearney openly discussed his knowledge that the defendant was interviewed by federal law enforcement and that the defendant and her counsel were working closely with the U.S. Attorney's Office. See Exhibit B, and it was in one of his broadcasts. Communications authenticated by Mr. Kearney, Aiden, Turboy, and offered by his counsel in a January 8th, 2024 hearing for the extension of an abuse prevention order sought by a former girlfriend. So now communication from that hearing coughed up what basically his phone records. So check this out.
And that's what we're always told by law enforcement that we're friends with is if you have any other cases, if you have other cases open, it'll lead to things being discovered. So you want to keep that in mind.
Yes. Whoop whoop. Partnership, baby. Partnership. It's called a partnership. I wanna make my memberships be called partnerships. Can we get that to change over here? Can we talk to YouTube about that? I believe that memberships be called partnerships. It's like you're buying some stock into the channel. It's how confident you are in the channel. Now, communications authenticated by Mr. Kearney and offered by his counsel in a January 8th, 2024 hearing for the extension, like I said, of these also revealed that on November 28th, 2023, that Mr. Kearney received information, presumably from the defendant or counsel, presumably, again, there's no proof of that, from the defendant or counsel about the feds that I will not be making public, and details a phone call that occurred days prior between Yannetti, Jackson, and Levy. See Exhibit O. Let me see your O face. And this is highlighted because it's a very good exhibit. This they pulled from his shit. Let me move like this again. I found out some information on the way home about the feds that I will not be making public, sent to his attorney. Now, isn't this client-attorney privilege?
I think it depends.
Did he, I mean, what the fuck?
His attorney.
Let me read again how they say that they got this. Oh, it was offered. See, it was offered by his counsel. Yeah, remember when we were eating lunch, I said, what the fuck is he doing? Yeah, see, this was offered by counsel, because you cannot go through client, like this is client-attorney privilege. This conversation would have been privilege, and it got offered up somehow because probably something that he was being blamed for. He's like, fuck
here's
that.
The thing. There are exceptions to the law of privilege.
No, not this.
You gotta look at
Not this.
It's even cited in there.
Okay, you have to have somebody go, but it says right here it's offered, so it's.
You have to look.
I want to look into more why. I want to go check out this January 24th hearing as to how this even fucking happened. But anyways, then so he says questions been asked. Really? Says his attorney. Good or bad? And then he says, yes, they requested a conference call over the weekend. Josh. Asking questions like, is there any chance the trial date could be delayed? Only one reason to ask that, asking for all communications with the DA office, asking for Jen McCabe's cell phone records be sent to them as soon as they get them. Keep in mind, feds likely have Jen's phone records already, so they may want to see them because they suspect whoever hands them over to the defense will delete things. Sent. This is his attorney. Well, no, this is him sending it again. That won't match up with their records. The mere fact that they are the ones seeking out Karen's lawyers tell you that this is far from over and that they want more info for this case.
Now think about why we even have our hands on this. Now that's kind of bizarre too, because it could be prejudicial. Like it could taint a jury pool, you know? I think it's interesting.
So we'll see how that, okay, let me go back to do it how I want to with, what in the motherfuck shit. Okay, so there, we'll come back to this. Yeah, I think there's gonna be a lot of questions about Fruit of the Poisonous Tree, don't worry. So we'll see. Again, that's why I highlighted that. Now, this is nothing new, because remember the Verizon records, they got all messed up. Remember? They got messed up, and so therefore they had to resend them or whatever. Now, it kind of raises questions for me with this, about all of that, with that date and everything. But, and all that your homeboy said is, if you are contacted by media in the next upcoming days or weeks, we would appreciate it if you did not mention us working together. And so, again, you have to go back to that you have to go back to that May email letter. You have to go back to that, your DA's letter saying that there's a huge conflict of interest here. And does this also, you know, you guys, I'm all about fairness, okay? And somebody raises questions on like, yeah, well, guess what? These people shouldn't be investigated because they have grudges against me because this is what happened back then and blah, blah, blah. We're asking, go ahead, investigate us, do whatever you want, but not with these people. Well, Karen Reed's saying the same thing. We don't want Proctor and the people that investigated, the John O'Keefe case, okay, to be the ones that should have been investigating that with the relationships that y'all have had. It's a conflict of interest, right? So it's funny to me that how does it feel when the shoes on, when you're going to go ahead and now you have to wear my shoes? That's what I see. And we're talking about tit for tat. That's exactly what I see. And here, like the jury, they're not going to see any of this. So it's a matter of what's going to come out in this federal investigation. What information is going to be uncovered? I think I think whether or not Karen Reed is found guilty or innocent, I think that this is going to be appealed, and that both grounds have sides that you can appeal here, because this is just such a shit show. It's so convoluted. Like I've said, it is so convoluted because the plot has been so far, like, we're not even talking about the case here anymore. Like, let's go back to the facts of the case, right? But then when you go and say, like, let's talk about the facts of the case, then that's where it's like, well, we can't even talk facts about the case because it was compromised from jump. That's what I see. And again, my opinion. Why would he ask that unless he knew something was going to happen and they were contacted for comment? See, okay. It appears the defendant is sole source of information for the federal investigation surrounding the case, as the U.S. Attorney's Office never requested a police report. Okay, so here. Now, this was interesting. It appears the defendant, who would be Karen Reed, is the sole source of information for the federal investigation surrounding this case, as the U.S. Attorney's Office never requested a police report, photograph, sworn grand jury testimony, witness list, third-party record, or piece of evidence from the Norfolk District Attorney's Office or investigators from Massachusetts State Police. It is apparent from the statement attributed to U.S. Attorney Levy and the information shared by the defendant that the U.S. Attorney's Office is working closely with the defense. Now, that to me doesn't make sense with a prior statement in this actual motion, when it's saying that they were contacted and turned the stuff over. When I was contacted, we've never been contacted. Like, they've only ever asked for stuff, discovery stuff, and we've provided that. So maybe he's just specifically saying, like, the feds haven't talked to us. You get what I'm saying? Like, it's just been so. Now, on January 18, 2024, Attorney Yannetti falsely represented to this court that District Attorney Morrissey is well aware he's the target of a federal investigation as a result of his conduct in this case. That's the date that it was H-bag, January 18th. So then I want to find out what was said on May 3rd. Something was May 3rd. Something was said on those in court. Okay. That same day, the U.S. Attorney's Office took an extraordinary step. Now, you guys know, did you guys go to government class? You guys were in high school. Did you guys like skip it and smoke some blunts and joints and shit? I want to make sure everybody understands this. All right, so there's 3 different offices. So when we're talking about the Attorney General's office, boom, that's the guy with Josh Levy. The district attorney is the prosecutor, plus the guy who runs it all, your DA, who's Morrissey. Okay, so Morrissey he oversees all his prosecutors. And this prosecutor is what? Talley. He got picked. Hey, you're going to prosecute the Reed case. So he takes his orders from his DA. Like that's who he works for. So there's like a bunch of prosecutors that work for your district attorney, depending on how big your area is. Okay. Your Attorney General's office is to basically make sure that there isn't any, if you have a complaint, you can report somebody. They can look into, it's for citizens, it's for corruption. Okay. So these are different offices, but just so you guys know who's who that are following along, but he's your DA. Talley, who is prosecuting the case, works for him. Okay, and he's the one that got picked to prosecute the Reed case. All right. Lally, not Tally. Not Tally, Lally. Fuck shit. Should be called Tilly.
We're talking about Tully, so
we were talking about Tully in the Moore case. So Adam Lally. Let's call him Titties. Call him Spike. So there we go. We'll come back to that. All right. Lollygagging around. I love Shelly. Lollygagging. All right. Oopsies. So right here. When Yannetti said this, now the state is then saying that the U.S. Attorney's Office took an extraordinary step to publicly rebuke Yannetti's representation by stating, "We are aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity as a target of an investigation to anyone. Attorney Yannetti's dishonest, widely publicized representations were made with the sole intent of materially prejudicing the criminal proceedings." Okay. As of February 14th, just a couple days ago, neither the district attorney, his assistants, nor Massachusetts state police troopers assigned to the Norfolk Division or District Attorney's Office has been advised that they are the target of a federal investigation. The evidence, which includes numerous independent laboratories and experts not affiliated with the Commonwealth or the Massachusetts State Police, have not discovered a cover-up of evidence, police misconduct, nor a good faith suggestion that the defendant has legally viable third-party culprit defense. Now, we're gonna under the guise of pursuing a third-party culpable defense, it appears that Attorney Yannetti distorted information and shared those mistruths with Mr. Kearney to publicize a false narrative. They are going hard right here, this ending here, at Yannetti. Mm-hmm. Like, whoo. Okay. This is the publicized mistruth, which is that Colin Albert, a juvenile, on January 29, 2022, and an individual not present when the defendant and victim arrived at 34 Fairview Road as the individual who committed the murder of John O'Keefe. As Attorney Yannetti is well aware, this opinion is contrary to the evidence and likely shared with Mr. Kearney as the rules of professional conduct would expressly prohibit Attorney Yannetti from speaking such a baseless, prejudicial allegation.
And it said likely shared.
Yeah.
That Yannetti likely shared.
Yes. So basically, basically what they're saying is we're not going to fault Turtle Boy here. Fuck that. You guys manipulated this poor little 42-year-old man who needs mommy to write letters to get out of prison, jail. We're going to go for the attorneys because you guys used this man, manipulated this man, told this guy bullshit. Okay?
Maybe they want to create division.
Now, let's take a look at Turtle Boy's personality and let's take a look at Yannetti's personality. I don't see that. Okay? I don't see that. When was Alan Jackson retained?
By Karen?
Mm-hmm.
It says in that correspondence right there, you have it right there, but I can check.
So
Or
check
chat right now.
check this out. This is where this is where, here we go, ready? February 2022. So again, murder, manslaughter, whatever you want to call it. John O'Keefe dead. January 29th, 2022. Literally the next month, in February 2022. This is going to be a big name because I believe that these two people, there's a reason that he's bringing up this man right here, right now. It's because I believe that in their motion, again, I don't have the motion. Nobody has the motion. It's sealed. But the only reason that you would ever bring up this man is if in that motion that the defense filed, they bring up this man. And that to me is the only reason that you would bring up this man. And what they're basically doing right here is they're pointing the finger at each other to say who came up with this theory, which is that Colin Alberts beat up and then ultimately John O'Keefe died from those beatings. Okay? So again, we don't have this motion, but I'm telling you right here now, February 2022, right off the bat, this guy, Stephen Scanlon, a private investigator, contacted and met with Attorney Yannetti. See exhibit.
So it was September 2022.
Yes, September 20. Okay, perfect. Break down that.
It was retained by her.
Okay. Now, see Exhibit M. Exhibit M is the most important exhibit, in my opinion, in this document.
Oh. Well,
It's more important than the letters only because I just believe what I believe and that they're going to be pointing at who said what and whose theory was what.
I was just commenting on
Documents. Okay. Because of Turtle Boy's Live, where they publicly bring up the name Stephen Scanlon. September 12th, 2023, they then go, meaning they, Proctor, and they go and they interview this man to get a witness statement out of him. Now, I'm going to come back to that after I read this part. Massachusetts State Police report dated September 12, 2023 and October 17, 2023, because when they went to see Stephen Scanlon the first time, he said, I want my attorney present with me, and that's what all of us should do. Not that I'm not going to work with you. I want my attorney present with me, set up an appointment with him, and I'll be happy to talk with you.
Because if you're being questioned,
Yeah, anytime you're being questioned,
you are potentially being looked at.
well, yeah, somebody accused you of something somewhere. Why is your name being brought up? Your name isn't just mentioned to the police just because they're like, oh, hey, by the way, on that same day, I had a phone call with Lana. I don't know if you need to know that. Like, who's Lana? You know, like, who's... So these are just the things that I've learned over the course of my life. And even if you think you have nothing to do with anything, you have something to do with something because they come into you for a reason. Now, Mr. Steve indicated he knew Brian Albert and was interested in helping the defense, but did not have personal knowledge about the case, nor did he speak to any witnesses or have insider knowledge? See Exhibit M. When Attorney Yannetti inquired of him about 17-year-old Colin Albert and an ATF agent who was at 34 Fairview Road, Mr. Scanlon denied knowing either party or details about their association to this case. See Exhibit M. Mr. Scanlon did not conduct any investigation for Attorney Yannetti, and it appears their relationship terminated in February of 2022. Again, see Exhibit M. 16 months later, in June of 2023, Mr. Scanlon received a phone call from Mr. Kearney that was recorded.
Illegally.
Unlawfully. This is where he's going to get in trouble. This is the only thing that I've seen that, in terms of like, this is breaking the law. Because he admitted to doing it because he played it. He stereotypically recorded. See Exhibit M. Mr. Scanlon suspected that Attorney Yannetti provided his information to Mr. Kearney. Now remember, this is now 16 months later. Why was Turtle Boy, who told Turtle Boy, hey, why don't you give that guy a call? Why don't you talk to him? Somebody had to say that, right? Because out of the blue, Turtle Boy is just going to call this man up. June 2023. Let's see. And during this unlawful recorded conversation, which was published briefly on TV Daily News, Mr. Kearney pressured Mr. Scanlon to adopt assertions that he had personal knowledge Colin Albert was involved and to state that he knew John O'Keefe was killed inside that house. Both statements were categorically denied by Mr. Scanlon on this call and are contrary to the evidence. Okay, again, I'm like, wait, what? Why? So I said, hey, you know what? We're going to go check out that police report because I was like, this is wild, right? Approximately 3 months after that, on September 6, 2023, Mr. Kearney posted a story that deceptively mischaracterized Mr. Scanlon's statements and falsely represented Mr. Scanlon as a whistleblower to scapegoat Mr. Scanlon as the supposed tipster that could buttress the defendant's unfounded theory that Colin Albert was involved. Again, what in the fuck is going on? Again, this was episode 133, Whistleblower Private Investigator Steve Scanlon's call to David Yannetti's office was turning point in Karen Reed defense strategy. Okay, do you see that? Now, remember what I just said 10 minutes ago? Why the fuck is Adam Lally mentioning this in this motion? Well, I believe that this name is mentioned in the defense's motion. Again. Let's see. All right. Now, Mr. Scanlon has expressed frustration that lies were being spread about him and his involvement in the case, calling the situation bullshit as the defense has dragged him into a murder case that he is not involved in nor has personal knowledge about. Again, see Exhibit M. I'm like, oh my God, this Exhibit M has got to be off the hook because this is very serious. Further in this September 6, 2023 post, Mr. Kearney writes, our sources at Moakley Courthouse tell us that Steve Scanlon has been subpoenaed and testified in front of a grand jury specifically about his contact with Brian Albert and his knowledge of what happened inside 34 Fairview Road, Exhibit L. And an inference can be made, an inference, did they spell that right? Can be made that this source was the defendant or her counsel, as the first contact the Massachusetts State Police had with Mr. Scanlon was on September 8th. See Exhibit M. Contrary to the defense's representations, the Norfolk District Attorney's Office has no bias or prejudice towards the defendant or a personal stake in the outcome of this prosecution. So I said, okay, we gotta fucking take a look at this. What is going on? What the hell happened? So again, they try to talk to him on the September 12th. He said lawyers. Okay. And zooming like this, make this bigger. So somebody's lying, and we're about to find out who. Somebody is a lion and lying bad, but then they meet up with him on October 16th, okay? And let's see. Here we go. It's important to understand that he reached out to Karen Reed via Facebook, and he said, I'd be willing to do it for free of charge. And then Karen Reed recommended that Stephen contact her attorney. So that's how they got in contact, okay? So Stephen stated that he initially reached out to Karen Reed over Facebook Messenger and told her that he was a private investigator and he would be willing to put another set of eyes on the investigation. Then Stephen then said he contacted, he wasn't sure of the exact date, but that he eventually called Yannetti's office and offered the same services, suggesting that O'Keefe might have been beaten up and that he was not sure what happened, but would be willing to work on the case, obviously only if agreed on by Yannetti and his client. And for free, okay, and for free. Now, for as quickly as he got in touch with them, like I said, this was February that he messaged her. Stephen went on to say that following their phone conversation, David Yannetti asked Stephen to come into the office for the dismissal. Stephen did back in early 2022. Stephen went on to say that during his visit to Yannetti's office, there was another individual present there, and he's another PI. Now, during the meeting, Stephen was asked, this is according to Stephen, he was asked if he knew who Colin Albert and an ATF agent, both of whom were allegedly in the home during the evening hours when O'Keefe was killed. According to Stephen, so this has been way before like Turtle Boy was around or anything, okay? To be saying this, to be coming up with this, Stephen is saying that this took place, so Turtle Boy's nowhere in the picture. Okay, these dates are really important. Back in February of 2022, right after this happened, this guy comes bolting through saying that, hey, he thinks that O'Keefe was beat up. Again, according to Stephen, this was the first time he had heard of Colin Albert and an ATF agent being possibly involved in the matter, and both had been mentioned by the PI, Paul, and Yannetti. Prior to the meeting concluding, Stephen stated that Yannetti handed him a check for either $1,200 or $1,500 and asked him to keep his eyes and ears open in the Canton area in regards to the O'Keefe case. Although Stephen took the check, he consulted with his attorney and returned it back to Yannetti, since he was not working on the case and he further felt it would be a conflict of interest. Now, why in the fuck would you go to Karen Reed, okay, and tell her that you would want to work on the case for free, and now all of a sudden you're going to say, okay, you leave, and you clearly talk to somebody who he's saying he talked to his attorney, and his attorney's like, hey, you need to go return that money and you need to stay the fuck out of this, basically. Okay? But he's claiming that there would be a conflict of interest. Wouldn't you know there was a conflict of interest before you ever message Karen Reed online to say, hey, let me help you with this. I think John was beaten up. I mean, Karen Reed didn't go to you. You came to her, so wouldn't you? What conflict of interest would there be? Unless you're trying to say, because then as it goes forward, so then check this out. In the days and weeks following their meeting, Stephen was in communication with an individual named Jack Hollow. Mr. Hollow, according to Steve, is a mutual friend of both Stephen and that Paul guy, and used to do work with Brian Albert. So y'all both know Brian Albert. So y'all both have issues with, you got beef with him. Hollow shared information which he had learned from Paul. That information being that Yannetti and his team were looking into Colin Albert and the ATF agent since Colin allegedly had beef with O'Keefe. I asked Stephen, like meaning Proctor, how come he did not reach out to investigators when he learned this information? Why would he? To which he stated that everything he had learned was fourth, fifth, or even sixth person removed from the source. Thus, he did not think that it was credible or important to reach out to us at that time to say what, hey, just so you know, I offered you some PI work. And while they were talking, they really think that this Colin Albert and this ATF agent beat the fuck out of, what? Isn't that weird? Like, I think that would be why don't you come to us and tell you what? I don't understand what they were supposed to tell you. So at this point, Stephen circled back about an event he had mentioned earlier in our conversation. Stephen had told us that he was at Patty's Irish House in Newton for lunch one of the days following the homicide taking place, and the local news was broadcasting coverage on the case. He sparked up a conversation on the matter with the bartender. Woohoo! He's getting his information from the fucking bartender of a bar. This is what's going on September 2023 when a case is supposed to go to trial in March. And they're meeting with this PI. And he's like, yeah, I went after a couple days of the homicide. I was at this bar and this bartender was telling me, are you kidding me? But bartenders do have a lot of juice. They got a lot of information. Yeah, Jan. One second. Back. Woo! Okay. he sparked up a conversation. Okay, this bartender. That the bartender who told him that she lives in the neighborhood where O'Keefe was found, and that the days following the investigation, she received a call from an unknown party telling her that the police were looking for ring camera footage and not to release it to the authorities. Holy shit, who's this bartender, man? I can't wait to go. I cannot wait to ask this bartender what's up. Like, don't give any of your ring to the authorities. Oh, shit.
Mom.
Thank you, babe. So then I was like, okay, wow, that's crazy. So Stephen didn't know the bartender and only provided a physical description of the female and her appropriate age being in her 30s. Stephen told us that he also shared this information with Yannetti during their meeting as well. Ring info, bartender. Okay, pick. I hear you. Yeah, should be very, very interesting, especially if anything is revealed. Stephen once again reiterated that he told Yannetti and Paul that his opinion and theory was that O'Keefe looked like he could have been beat up, but he had no personal knowledge of what actually happened or who could have been involved in the murder. The name Colin Albert and this ATF agent were mentioned by Yannetti and Paul in the meeting, and it was not Stephen. See? And not Stephen. This is what tells me in this motion, I feel like Stephen is being labeled as the person that said, wait a second, you're the one that brought this to us. Okay, just like you're the one that went to Karen Reed. So that to me is going to be interesting because I think what we have right here is we have people blaming Stephen because, which makes sense because why in the world would Turboy be calling this dude? Unless you're like really going to say to yourself, we have to go and set up this guy. So now, again, this is what's kind of interesting to me is that why would this guy contact Karen Reed if he's like an old good buddy friend of Brian Albert? Because wait till you hear like their relationship. I'm not buying this from this guy. I don't, something's off with this. And I'll tell you why here at the end, because he knew there's a conflict of interest from jump. We asked when was the last time he spoke to Brian Albert, since the two used to work together. Stephen told us that he last spoke to Brian in April of this year. April of this year. And that he considers Brian a friend. Stephen told us he knows both Brian and his wife. He has also met Chris Albert and Kevin at Brian's house years prior. Stephen estimated it would be around like 1998, 2001, during that time when Brian was in a bad car crash and Stephen would stop by the house to check on him. Yeah, K-Pick. Yeah. And I think that 100. It's almost like, was he sent by them? You understand what I'm saying? Like, what were his true motives when he contacted Karen Reed in the first place saying that I'll do the case for you for free? And to like get in with that side. And when right here, so you're going to tell me you're friends with Brian Albert, you would have known this happened at that address, and you hit up Karen Reed and tell her team that you think that he was beat up. I'm sorry, but if I found out that this happened, you don't know Karen Reed from a hole in the wall, right? You are friends with Brian Albert, and you see that this happened at his house. You're not hitting him up to say, holy shit, what's going on? Makes no sense. But what they were able to do is to get this guy to say all this shit, put in a police report, and then this then could be used as it's being used in this motion. But I question his true motives, this Stephen guy's true motives, when he contacted Karen Reed. And I think that there'd be enough, based on his name being put out like this, I would believe that there's enough to go get a subpoena for this man's phone record and to see when the last time he truly did talk to Brian Albert before April of 2022 or 23, whatever he said in this. They asked him when the last time he talked to Albert. Well, I want to know after the murders, or after the murder, when did you, or whatever they're calling it. This is wild, though. Wild. So basically, we got people pointing the finger on who started the Colin Albert theory with the ATF agent. That's what's happening right now. Because I believe that the two PIs are pointing the finger at each other. That's just my take from reading between the lines. And either I'm doing a horrible job at it or a decent job at it. Now, this is interesting. When Turtle Boy does his live, okay, Stephen was asked if he ever had a phone conversation with Aiden and whether or not the conversation was recorded and so he tells him this. You know, Stephen said that approximately June, he spoke with Turtle Boy following Saturday night. The following morning, Sunday, after the show, during the episode where Kearney mentioned Stephen by name and his alleged connection to the case, Stephen woke up to a Facebook message from Aiden stating something along the lines of, tick-tock, you should call me. You shouldn't be scared of Brian Albert. You should be scared of me. I think that he should have never wrote that. I think that is harassment. I also think that's a threat. Okay. And that state, like that sentence right there reminds me of somebody that I know all too well. Now, Stephen told us that he asked Kearney for his number and called him. Prior to talking with Kearney, Stephen told us before I speak to you any further, is this being recorded? To which Kearney, Aiden Turboy said, absolutely not. That would be illegal. During their conversation, Stephen told Aiden that he did not know Colin or the ATF agent in question, and he didn't know anything about the case. Aiden told Stephen that he was not talking to the defense, but to close friends of Karen's at the time when they talked. That would have been in June, which based on a timeline is not true. But who cares? I can lie to you if I want to lie to you. It's not against the law to lie to somebody. And this is where he's going to, and then he says, and that is where he's getting his information from, these friends. Stephen told us that he suspected that Yannetti was feeding Aiden his information on the case and the investigation. Stephen recalled sitting on the beach during the summer of 2023 when a friend of his, Irish Ray, who is also a retired private investigator, contacted Stephen and told him about the conversation that it was shared online. Like, what a fucking moron to put that out online. This was the same conversation that Aiden assured Stephen was not being recorded. Stephen went on saying how upset he was about Aiden recording with him without his consent, especially after promising that he didn't do so. Stephen had to fight back tears as he told us how upset he was having Aiden drugging his daughter into this mess. If that is at all true, shame, shame, and shame. Stephen told us that Aiden told him to call a 401 area code number. So that's it. Now, in this motion, in the end, they are asking the conclusion is to say that we want this should be denied. And then they go on to say, fuck all that. Not only should this be denied, but this, they are asking to renew its request that this court impose that gag order. The court has affirmative, it's just right here. During a September 15, 2023 hearing, defense counsel acknowledged that national publicity will only intensity as a trial approaches, whereas by statement attorney Yannetti, in his opinion, he boasted that defendant is the most infamous criminal defendant in America. Further, immediately following the court said, I can guarantee you that Karen Reed and her family will never quit, ever quit until the truth comes out, not until John O'Keefe's killers are brought to justice. The danger of publicity surrounding, so they're going on about that. That's why they want this gag order. They're saying they're the ones that are saying all this extrajudicial statements. Furthermore, the defendant has previously scoffed at the Commonwealth's absurd efforts to preserve her rights. So look at this. Furthermore, the defendant has previously scoffed at the Commonwealth's absurd efforts to preserve her rights to fair trial and claimed that the Commonwealth seems to be arguing that it knows better than Ms. Reed's legal team how to best preserve her right to a fair trial. Exhibit G. The Commonwealth does not claim it knows better than the defense team. However, based on the full picture of representation presented before this court, the Commonwealth has genuine concerns about possible post-conviction claims, and that they were like, listen, we want you to sign off and say that you're not going to get these ineffective, assistance of counsel claims because of the stuff that they've done. So right here, this is what they're nervous of, is that the defendant can claim that Attorney Yannetti and or Jackson were ineffective for violations of Massachusetts rules of professional conduct and for what the Commonwealth can only assume to be radical, tactical, strategic decisions. Therefore, the Commonwealth respectfully requests this court engage the defendant in a thorough, basically, here are your rights to effective representation, and should the defendant wish to proceed with these two, a clear finding that the defendant waives any legal claims challenging the assistance of her counsel. I don't think that that's going to happen, but now, I'm only interested, like I said, in the facts of the data and what the data is going to show. But you show that O'Keefe was in that home, which I think you're going to show the flights of stairs. He wasn't using the Stairmaster in the middle of the driveway. He had to go up a flight of stairs, and he did it so quickly as to when they arrived on the property that one can only assume that he's in the house. Where else would he be? With that being said, if he's in the house and he's walking around in the house with all the amount of people that were in that house, nobody saw him. I don't think any jury, I would never believe that. And so once you put him in the house, then now it's a timeline crunch of what then happened and how quickly then Karen Reed was gone or not gone from the property. And I think I did this right. Beautiful. And so that's where I'm at with everything. It's going to, they may have text messages about, F this, F that. But as far as text messages go, Karen Reed was texting him that night. I still think it's interesting, the thought of, when they first arrive and, he gets out of the car, her version is that we were never invited there, right? We weren't invited there. Because I don't know what type of GPS her car has, in her phone. I mean, what type of apps they have. But I'll tell you that if you have if you have Gmail downloaded on your phone with an app and you have your locations on, that your phone, it's GPS. So like, if Karen Reed pulled into the driveway at first and then pulled out to then park up on the side, to not block the driveway, because why wouldn't she be getting out of the car, with him? And they say, well, was he running in to see if it's okay if they come in? Like, what? None of that makes any fucking sense. None, in my opinion. Absolutely none. So I'm interested in what's going to be admissible and what's not going to be admissible in this courtroom. Based on John's phone, I personally believe that he went out back and went out the back of a slider and instead of going out the front door, I don't know if he got turned around in the house when he used the bath. I think that he used the bathroom in there. If you're drinking all night, that's the first thing to go to the bathroom. And so I feel like he went to the bathroom. I feel like that was his first flight of stairs, was to go up and to go up to use the bathroom. But there was also a bathroom on the first floor all the way to the back. I did the layout of the house. But I'll tell you this. When I compared the phone records of John O'Keefe's and Jennifer McCabe's, and I put them side by side, and I did it on my Excel spreadsheet, the storyline that Jennifer McCabe and them are saying, it's impossible. Jennifer McCabe and John O'Keefe's phones are both stopped at the same time, both taking steps at the same time, even once he arrives at that house. And it's like he sat down or he was laying down, and his phone and her phone were both not moving. And then it was like, I don't know how drunk he was. He said, oh shit, I forgot to tell fucking Karen to come in, or I'm going to tell Karen I'm staying. He went out, I believe, that back slider where the dog was. And then he ran into whoever out in that the back slider. If people are smoking cigarettes, if they're smoking back out on that back, porch. Was John a smoker? If he's a smoker, then even more so, to go out there and smoke. And something, then happened. But what's interesting to me is moving of the body. Wait, you think he got beat up outside? Yeah, in the fenced-in backyard. I think it's quite possible, yeah. Then why the change? The floor is not once but twice in the basement and fill in the pool. Why fill in the pool? People have been filling their pools a lot to sell houses now because it's such a liability. I will say that. I'm very curious to see what the Cellbrite person says, or an Apple specialist says about the going up or down a set of stairs. Because if you go down a set of stairs, does it count on your reader? So I'm interested to hear that. Yeah, go check out those if you go look at my other Karen Reed videos, go check out my timeline with my spreadsheet. It's very interesting. I believe 100% John O'Keefe was in that house. So the only way that it would be possible that Karen would hit him in some capacity is he went inside, then he came outside, and then he hit. And I think that the timestamp will show that she's already gone. Also, he didn't take enough steps to get from being back from inside the house to out where that car was. Also, when they carried him out, I believe they shut off his phone. And it was on him, and it was shut off. You'd have to ask. I mean, it's all right. They're going to know if his phone was shut off. Because I think at first they plan on leaving it on him, and then because there's nobody out walking his phone to him, like after the fact. Like, when do you think they put him out in the cold, reading out front? So I think the movement with the phone is really telling. Because I think that they were planning on keeping it on him. Then they thought for a second about discarding the phone. And they realized that, well, how would he not have his phone if he just got hit by a car out there? So they put it back on him. Well, the 911 recording on his voicemail, his phone was on. Huh? I'm talking about earlier than I'm talking about I'm talking about the decisions made during like the night. Hey, Lan and friends, I thought they were invited by Karen's stomach, but it was her news event. She went home. Well, she did that interview with, she did an interview over the summer in 2023. And she says something a little bit different. She didn't even know that they were invited. I really don't believe that his phone was found underneath him. All I can tell you is that once they arrived there and they were at his body and Jen McCabe's phone starts moving, his phone starts making steps. It's like this. What it looks like to me is when they pull up in the truck and they all run out of the car, you're not thinking to grab your phone, so the phone's just like sitting, in that vehicle. They run over, and then she has to run back to the vehicle to pick it up and start calling 911, and then she starts walking with the phone then. And I think when she was over at the body, I think that Jennifer McCabe grabbed that phone. I mean, I know she did. I know she grabbed that phone. Those two phones are moving at the same time when his phone starts making steps. I believe it was in his, it's not possible for his phone to be found underneath him. Jen's 911 call was recorded on his, and CPS would see that it's not in one of the reports. I'm not understanding what you're saying. Jen's 911 call was recorded on his voicemail. That would mean that somebody was calling his phone. When I say turned, your phone could be off and you could still leave a voicemail. Yes, it was in the car with her. Yeah, I either believe that it was in his jeans pocket, and when I say it was, I don't think it was underneath his body. No, I don't think that at all. They were deciding what to do with that phone. The phone, this is how I know that I don't believe that it went with Jen McCabe anywhere, is because there's no additional steps with that phone. Like you have to go and you have to look at the night of the incident, and his phone, aka him, they say, it stops making any steps at a certain point, and it's not like then like an hour later or an hour and a half later it takes a couple steps. Okay. So that phone would have had to be turned off. And then, I mean, that's only on like I said, that Apple. If you look at I'm just curious to know what apps he had on his phone. And there's a lot more you can tell. I didn't even realize that if you have, like right now, all of our phones, if you got Gmail as an app on your phone, your phone's GPS right now. Jennifer is involved, in my opinions. Involved in the cover up, and then they decided just to dump it on her. But you can't say any of that because, oh yeah, no, fuck no. They didn't find that underneath his body. They were debating. His phone is literally running laps around the street. They were debating what to do with that phone. They passed that phone off to somebody, and they were debating what to do with his phone. And I wish just Jen would have been a little bit more with it and not, she was hysterical to be saying things like, where's his phone? Where's his phone? Where's his phone? I'm curious if they're going to be able to get to one of the witnesses with this federal probe, and if there's information to come out, if somebody cracked under the, being talked to by okay, hey, fine, fuck it. I'm going to say what happened, but I was told to do all this stuff. I had nothing to do with this, but I was just told to say this, this, and this. So I'm curious if that has, came out. Karen called John's phone, but she didn't hang up. Jen's 911 call was recorded on John's voicemail. Yes, that I understood. I wasn't understanding when he was saying that up there. I believe the story was just going to be that the story was going to be that he was in the house, and they decided to change the story last minute based on Jen's condition. Based on her not remembering shit. Once that happened, then it was like that changed everything. So that wasn't the original plan was not to never blame Karen Reed. The original plan was to just, have him be found that he got what? He got pissed or he got upset, or you're going to have to say something as to why, oh, I thought that someone picked him up. You know what I mean? He said he was leaving. But or she totally ran him over. That's what I'm like. Those are, I don't see that. Because I personally believe that if that was the case, they all would have saw him. You know what I mean? Those people that were leaving, they would have saw him. If Jen in fact ran him over, when she left or whatever, those people that were coming and going, because there was multiple people, they would all saw him. That's how I feel. I think it's going to be an accidental freeze in the cold. Yeah. So, but thank you guys. But very interesting to see it from both sides. So, I'll see you guys later. I think it's, like I said, this is going to be a dog match. And very curious to see what the jury is going to end up being able to see with anything being suppressed. You know, we don't even have all the evidence in. There's a trial in just a couple weeks. So it's going to be interesting.
Well, the best thing is going to be seeing Alan Jackson present and Little present.
Mm-hmm. He's got a really good right hand. K-Pick, there just isn't any, from what we know and seen, factual evidence of anyone running anyone over. That man's 6'2", 230 or something. The rate of impact and death rate is less than 20%. Yeah. All right. I think that I see this case going to trial more than once. Even if she's acquitted, they're going to appeal and they're going to win. If she's, you know, found guilty, they're going to appeal and they're going to win. I see this being, I don't know. But if it's a mistrial, you know, then there's no trial. I just see there being more than one trial in this case. That's all. Have a great weekend. Yeah, everybody do too. Woohoo. Battle of the experts. It goes to trial. Yes. They put him. I don't know what expert with phones is going to be able to get up there and say that he wasn't in that house because of the going up a flight of stairs. That to me, how do you account for that? You know, how do you account for that? I don't think that, just like you're going to have one expert that's going to say that this is from a dog / Mike Tyson fight, and you're going to have somebody else saying that it was, and I always look at witnesses and I'm just like, okay, it could be this, it could be that. It's science, right? We don't know. Boom.
And that's when the attorneys and the questions they ask is the most important thing.
Yeah, Monday's going to be a good hearing. A lot of hearings is coming up week, but I'll see you guys soon. Join me late night. Idaho 4 talk later. Bye.